Let's start this course by introducing the Uniform Commercial Code. For those of you who have already had another course in commercial law, for example, secured transactions, you will already be familiar with the UCC. But for many of you, this course will be your first real exposure to the UCC. So let's start at the beginning. What is the UCC and who created it? The UCC was a joint project of the National Conference of Commissioners on Uniform State Laws, a private organization also known by the acronym NACUSL, or by its shortened name, the Uniform Law Commission, or ULC, and the American Law Institute, the ALI. You may remember the ALI as the elected body of legal experts that has drafted various restatements of the common law that you have likely encountered in your previous studies, including the restatements of contract and the restatement of torts. The UCC was drafted as a model law, a model statute drafted with the intent that states would enact it. So the UCC is a model statute created by private parties, the ULC and the ALI, but it gained legal force when the UCC was enacted into law by individual state legislatures. The goal of the ULC and ALI in drafting the UCC was to promote uniformity and consistency in the law governing commerce. And you can imagine how critically important legal uniformity and consistency would be given the scope and volume of interstate commerce in this country. It would raise all sorts of complexities if, for example, the commercial laws of Oregon were different than, or perhaps even in conflict with, the laws of California, Idaho, or Washington. Originally promulgated in 1952, the UCC has been a tremendous success at accomplishing its drafters' aims. The UCC is currently adopted by all 50 states, except that UCC Article 2 and 2A have not been adopted by Louisiana, which of course due to its civil law heritage has a unique legal structure. Although the UCC has been adopted by all 50 states, you should be aware that some states have adopted non-uniform variations to the model statute that the ULC and ALI promulgated to the states. What we will study in this course is the model statute, the current official version of the UCC as promulgated to the states for adoption. But because some states have adopted non-uniform variations to the model statute, that means that in practice, you must always look to the statute of the applicable state so that you can identify any non-uniform variations. Because to reiterate the point, the model statute has no legal force. The UCC as adopted by each state legislature is what is binding law in that state. The UCC is an expansive statute divided into 10 articles, and each article is generally designed to set forth rules to govern a particular type of commercial transaction. That's true of each article except Article 1. Article 1 is distinct and distinctly important for the UCC because the provisions of Article 1, including the many defined terms set forth in Article 1, apply to all of the other articles of the UCC, including Article 2, which will be the focus of our interest in this course. So as we examine Article 2 in this course, we will also need to occasionally look at Article 1's provisions, because the provisions of Article 1 apply to the entire UCC. At first glance, the scope of the UCC may seem quite broad, and it is, that's true. But it's important for you to also understand that the UCC does not cover all things that could be construed as a commercial transaction. For example, a sale or lease of real estate, a sale or license of intellectual property, a copyright or patent, for example, or a contract to build and maintain a website for a business. All of these types of contracts may be deemed commercial in nature, but none are governed by the UCC. Moreover, even with respect to the kinds of commercial transactions that the UCC does expressly address, the UCC is not a comprehensive statute. There are important areas where the UCC is silent and instead relies on the common law to supplement the gaps left unaddressed by the UCC's statutory provisions. Indeed, one of the most important provisions of the UCC is set forth in Article 1, Section 103b, which says that unless displaced by the particular provisions of the UCC, the principles of law and equity supplement its provisions. So where the statutory provisions of the UCC are silent with respect to a particular issue, the common law supplements the UCC to fill the gaps. And remember, because Article 1 applies to all of the other articles of the UCC, including Article 2, that means that where Article 2 is silent on a particular issue, we will need to look to the common law of contracts to fill in the gaps left open by Article 2. So for example, Article 2 statutory provisions address contract formation issues concerning offer and acceptance only scarcely. Because Article 2 is largely silent about offer and acceptance, Article 2 relies on the common law of contracts to define and determine what constitutes an offer and what constitutes an acceptance of that offer. In addition, The breadth of the UCC is further limited by other state statutes, federal statutes, and treaties that may supplement or supersede the terms of the UCC in various respects. For example, state usury laws may limit the amount of interest that may be charged even in a contract for the sale of goods. Likewise, state lemon laws applicable to the sale of cars may both supplement or supersede a state's UCC Article 2 provisions. One important limitation on the scope of the UCC that we will briefly discuss later in this module is the CISG, the Convention on the International Sale of Goods. The CISG is a treaty among various nations governing international transactions and goods. The U.S. is a signatory to the treaty and therefore bound to its terms. Stated differently, the CISG is federal law for our purposes. And because the UCC is state law, under the federal Constitution's Supremacy Clause, the CISG supersedes each state's UCC in the context of international sales of goods. Another set of rules concerning the international sale of goods that you should be aware of is the Unijoint Principles. Unlike the CISG, which is binding law in the US, the Unijoint Principles are not binding law. Instead, the principles articulate an internationally agreed upon set of rules concerning the sale of goods that parties in commerce may consent to when they enter into a sales contract. So, unlike the CISG, the Unijoint Principles are never binding on contract parties unless the contract parties agree to be bound by them for their particular transaction. Our focus in this course will be on Articles 1 and 2 of the UCC. As we said, Article 1 sets forth general provisions applicable to all of the other articles of the UCC, including Article 2. The current version of Article 1 is based on a revised version of that article that was promulgated by the ULC in the year 2001. As of 2017, this revised version of Article 1 has been adopted by all 50 states. But you should be aware that many states have adopted some non-uniform variations to Article 1. So again, in practice that means that you will always need to look to the statute of the applicable state so that you can identify any non-uniform variations in your state. As we have said, Article 1 sets forth general provisions and definitions that apply to all of the other articles of the UCC, including Article 2, which is the principal focus of our interest. Article 2 sets forth provisions that are specifically applicable to transactions involving the sale of goods. Article 2 has been adopted by every state except for Louisiana. The version of Article 2 in effect in every state is the same version of the statute that was originally promulgated by the ULC and the ALI in 1952. Aside from some minor technical revisions made in the years since, the 1952 version of Article 2 has been unchanged. Sometimes in practice, you might see references to a revised Article 2. In 2003, the ULC promulgated a substantially revised version of Article 2 for states to adopt. But the 2003 revisions proved hugely controversial and no state adopted them. As a consequence, in 2011, the ULC gave up and withdrew the revised Article 2, and the original 1952 version remains the model statute and the version of the statute that is the law in every state. One final note, you should also be aware of Article 2A of the UCC. Article 2A was not part of the original UCC that was promulgated in 1952. Rather, it was added later, promulgated by the ULC in the year 1990, and it has since been adopted by 49 of the 50 states, with again Louisiana being the sole exception. Unlike Article 2, which governs the sale of goods, Article 2A governs leases of goods. So for example, when you rent a car, that's an Article 2A transaction. Article 2A is covered in many sales courses, but it will not be covered in ours. Although leases of goods are quite common, most real-world transactions in goods tend to be sales, not leases. Moreover, Article 2A is largely structured on Article 2's basic framework. So once you have mastered Article 2's rules and nuances, you will be well positioned to tackle leases if you ever need to in practice. So that concludes our brief introduction to the UCC. With this context in mind, in the next video we can turn our attention to our principal topic of interest, UCC Article 2.